Hello everyone, welcome to StudyIQ IAS English channel. My name is Shubham Sagar. Today we have to talk about why is Tamil Nadu in news. So when we are talking about this article, at the end of this particular video, you will have 3 MCQs based on whatever we have read. So there are certain things which are going on in the background. Tamil Nadu CM MK Stalin sir, he is trying to gather all the CMs. He's trying to take into consideration the views of different CMs regarding whether states' power are being undermined in our current setup, current federal setup. There are so many terms here when we will talk about this particular article. Berubari Union case, Keshwanand Bharti case will also come into picture. Ayodhya dispute was there. Then presidential reference, Article 143 Clause 1, Article 143 Clause 2. If let's say Draupadi Murmu ma'am, our Honorable President, she is asking for opinion from Supreme Court, whether Supreme Court is bound to give opinion or not. So there are so many things which are important from exam perspective. At the end, as I have already told you, there will be 3 questions and you have to try to answer all of them and try to answer them all correctly, right? So May 17, 2025, Hindu page number 1. MK Stalin sir to hold talks with other CMs over presidential reference. You may have heard about this particular issue that Supreme Court verdict was there where they have talked about governor giving assent or dissent to a bill within 3 months. And now Draupadi Murmu ma'am has asked Supreme Court that whether in the absence of any such deadline rather, oh my god, explicitly written in the constitution, whether Supreme Court can give such verdict, whether they can set such deadline, whether it is going into the ambit of judicial overreach or not. Again, there are different concepts: judicial review, judicial activism, judicial overreach. So in judicial review, judiciary is checking the constitutionality of laws and executive order. Many people say that Shreya Singhal versus Union of India case, where Supreme Court struck down section 66A of IT Act, again, do check that, is an example of judicial review, because that section 66A of IT Act was impinging upon our right to freedom of speech and expression. Then you have judicial activism that is thrusted upon judiciary because of the non-functioning of or not proper functioning of executive and means legislature. So Keshwanand Bharti judgment, PIL, public interest litigation, all these are taken example of judicial activism. Again, this is not a hard and fast rule that Keshwanand Bharti and PIL, public interest litigation cases, are judicial activism only. Some people keep it in judicial review also, but many people keep it in judicial activism. Then there is something called as judicial overreach, which has a negative connotation. There was a Shyam Narayan Choksi case. There were other cases also, national anthem case and others. Like there was one case also where national highway and state highway within certain meters, liquor shops would not be there. So judicial overreach, when judiciary is trying to make laws, etc., which is the ambit of legislature. So these 3 words, judicial review, activism and overreach, we should also know about it. Okay, let's come back to the topic of the day. Chief Minister MK Stalin sir, what he is saying, he's saying that he would consult with other chief minister, because whatever presidential reference, like many people believe that Draupadi Murmu ma'am, she is asking Supreme Court for an opinion. In a way, executive is trying to exert pressure upon judiciary, and MK Stalin sir is saying that this is not correct and we have to consult other chief minister to decide on the next step after what Draupadi Murmu ma'am has done. Presidential reference issue at hand. Presidential reference concerns with Supreme Court verdict against Tamil Nadu Governor R.N. Ravi, where Supreme Court said that you cannot sit on a bill, you have to take decision within 3 months. And Draupadi Murmu ma'am is asking about this particular period from where we are deciding these 3 months, because this is not explicitly mentioned in the constitution. Stalin sir's criticism of the center, he accused the center of overreach and responded in detail to, again, this is just a snippet of the article. We are concerned with the keywords here. Like we have talked about judicial review, oh my god, judicial activism, judicial overreach. Similarly, there will be other things which we have to talk about. Article 43 Clause A, like Clause 1, Clause 2, where Supreme Court has to give opinion to President, where they can or they may or may not give opinion, in which scenario President has to listen to the opinion, and in which scenario President can ignore the opinion of Supreme Court. So there are so many things which we have to understand. So reference by President Murmu asking Supreme Court whether in the absence, please pay attention here, in Constitution there is no such limit that governor has to decide on a bill within 3 months. Then ma'am is asking from where we have got this particular, where like judicial ruling has happened, 3 months time period has been given, is it correct or not? So that is her question in simple terms. And Stalin reaction is this move is an attempt to undermine democratically elected state government. And they believe, and Stalin sir is saying that in a way governor is acting as an agent of central government. And anyway, India is a federal state with strong unitary bias. Slowly and gradually number of subjects in state list have reduced, and this whole thing, this whole presidential reference is also or will also try to undermine the power of state government to a certain extent. So that is what MK Stalin sir is trying to say, and basically he's saying that governor is agent of union government. Now, what's your opinion on this? Do you agree with MK Stalin sir? Do you believe that yes, governor is an agent of union government, or do you feel like no, governor is an independent post? It is also known as gubernatorial post. Again, whatever are your views, you can post it in the comment section. Now the keyword here is, what is presidential reference? We have to understand these words. Like we have talked about judicial review, activism, overreach, similarly presidential reference. So what is presidential reference? This is actually a scenario where president is seeking opinion of Supreme Court on different cases. It can be pre-constitutional treaties and agreements. In that scenario, Supreme Court has to give opinion. If it is on general laws, then Supreme Court may or may not give their opinion. So presidential reference is a provision under Indian Constitution that allows president to seek opinion of Supreme Court under Article 143 on important questions of laws. Now there are two types of opinions here which we have to pay attention to. Article 143 clause 1, please pay attention here because you can easily get confused, and that's why we will have MCQs at the end so that you don't get confused and you're able to solve it. So Article 143 clause 1, president can refer any question. Please pay attention to the words here. President can refer, just give me a second, any question of law or fact to Supreme Court which is of public importance. And under Article 143 clause 1, Supreme Court may choose to give its opinion or not. What does that mean? Supreme Court here, this particular scenario lies under Article 143 clause 1. So Supreme Court in this scenario where Draupadi Murmu ma'am is asking for Supreme Court this 3-month thing related to governors. So Supreme Court, if they want, they may or may not give the opinion, but that does not happen in Article 143 clause 2. Here Supreme Court has to give opinion, and here the dispute will be related to pre-constitutional treaties or agreements. So before 1950, there were certain agreements, treaties. It is also said that our constitution, 50% of the provision is from 1935 Act. So if there is certain treaties or agreements before 1950, and if president is asking for opinion from Supreme Court on that, then Supreme Court must give its opinion. Under Article 143 clause 2 must, under Article 143 clause 1 may or may not. So please pay attention here. So this is important. The keyword here is 143 clause 1. Supreme Court is not bound to give opinion. They can, they may, or they may not. But 143 clause 2, which is mainly related with pre-constitutional treaties or agreements, Supreme Court has to give opinion. In both the scenarios, like we'll talk about it. So purpose of presidential reference, because see, understand one thing, Draupadi Murmu ma'am or any president, so to say, they don't have full and every idea about every particular issue. It's not possible. We humans are continuously learning. So to clarify constitutional ambiguities, to seek judicial guidance, judges, they have more knowledge about these things, the laws and agreements. So they are the better judge. Obviously, judges judge to help the executive avoid legal pitfalls in governance. So that's why we have this Article 143 clause 1 and clause 2 presidential reference. Do remember in which scenario Supreme Court has to give opinion, in which scenario Supreme Court does not have to give, or it's not mandatory for them to give the opinion. The opinion given by Supreme Court under Article 143 clause A is advisory, not bounding. However, it carries great legal and moral weight, not binding on president. President may or may not, pay heed to that particular opinion. Now, past presidential references, in which scenarios president has asked for opinions from judiciary, from Supreme Court. Berubari Union case, where it was about, different enclaves being transferred to Pakistan and all those. So that was Berubari Union case. That happened with Bangladesh also, where there were certain enclaves, etc., which Bangladesh transferred to us and we transferred to Bangladesh. Then Keshwanand Bharti case, very famous case related to basic structure. Many people, when they talk about basic structure, they talk about Keshwanand Bharti case. Just remember one mnemonic which will help you a lot, because basic structure is explicitly given in your main syllabus, UPSC main syllabus. So remember this mnemonic, SGKMW, Shankari Prasad, Golaknath, Keshwanand Bharti, Minerva Mills case and Vaman Rao case. All these 5 cases led to the evolution of basic structure. So Ayodhya dispute, whether a temple existed beneath the Babri Masjid or not. So these are some scenarios where presidential reference have been taken. And the current context is this. To summarize, Draupadi Murmu ma'am has asked whether in the absence of constitutional time limit for governors to act on state decisions, can such limit or methods be set by the judiciary? Here judiciary has set 3 months time, and Draupadi Murmu ma'am is asking, it is not written in the constitution explicitly, so how are you setting the time limit and can you do that? This follows the Supreme Court verdict. Again, we have discussed it. Now let's solve some questions based on what we have studied. MCQ 1. Provision of presidential reference to the Supreme Court is mentioned under which particular article of Indian Constitution? 131, 136, 143 or 148? MCQ 2. Consider the following statement regarding presidential reference under Article 143. Opinion given by Supreme Court is binding on President. The Supreme Court is bound to give its opinion in all cases referred by the President. Third is presidential reference can be made on matters of public importance. You have to state which of the following statements are correct. Do have a look at correct or incorrect. Sometimes UPSC will ask incorrect. So 1 and 2 only, 3 only, 2 and 3 only, 1, 2 and 3. MCQ 3, the last MCQ of the day. The recent presidential reference made by President Draupadi Murmu in May 2024 is related to electoral reform, Supreme Court verdict on powers and time limit of state governors, interpretation of Citizenship Amendment Act, or use of central fund under the Finance Commission recommendations. So what is your answer? If you know the answer, you can share it in the comment section. I will share this PDF along with the answer of these 3 MCQs in my Telegram channel, Fun Study with Shubh, because study should be fun. Cool. And again, if you are a serious aspirant preparing for UPSC 2026, you can join our May evening batch. Batch has just started. You can use my code SHS Live to get maximum discount. And here you have Prelims and Mains Residential Program. You will get full refund if you clear UPSC Pre 2026, because you will be making us as well as yourself proud. But the thing is still not done. And you still have to write mains and interview, and that's why this is P2I, prelims to interview. We will guide you in interview, and if you are a monthly top performer, we'll give you 11,000 reward. So do join at the earliest our May evening batch. It will help you if you are a serious UPSC 2026 aspirant, and if you feel like you need guidance, you need mentorship, and you need proper support. We are there for you. So that's it from me, sir and ma'am. Whatever are your views on this particular issue, whatever are your views on what mkstalin sir said, oh my god, said, you can post it in the comment section. I have asked you 3 MCQs. You can answer it in the comment section. I have also asked you some questions in this particular video. Again, you can answer it in the comment section. So take care, be blessed. I will see you soon.